Good afternoon, everyone. I would like to call to order this meeting, our second meeting of the Domestic Violence Criminal Justice Response and Enhancement Advisory Council. Thank you all for being here today. We're going to attempt to make a quick, but I hope what will be a simple addition to our agenda for an approval and discussion of last meeting's minutes. And so with that, I will recognize Undersecretary Pelka.
Thank you, Madam Chair. Mark Pelka, Office of Policy and Management. I'd like to seek a motion, please, to add a new number 2 to the agenda, which would include review and approval of the minutes from the October 25th meeting of this council.
Thank you. Is there a second?
Second.
Thank you. Okay, so there is a motion made to add the minutes to our agenda, and there has been a second. Is there any discussion of adding the minutes to the agenda? Not the minutes themselves, but discussion of adding the minutes to the agenda. Seeing none, all those in favor of adding the review of last meeting's minutes to our agenda, please signify by saying aye.
Aye.
Any opposed? Abstentions? Okay, our minutes are now on our agenda. Okay, and with that, the minutes are before all of the members of the committee, and they were sent out as well. Is there any conversation? Well, first, I'd like to have a motion to approve the minutes.
So moved.
Motion has been made by Undersecretary Pelka. Is there a second?
Second.
And the motion has been seconded by Attorney Hardy. Any discussion of the minutes? Seeing none, I'll move forward with approval. All those in favor of approving the October 25th meeting minutes, please signify by saying aye.
Aye.
Opposed? Abstentions? Great. Thank you all very much. Okay. Next is the welcome and introduction of our council members. So since we are a new group, we'll go around once again and introduce ourselves just briefly, your name and the work that you do and what brings you here to this table. Just brief introductions. I will first start all the way over to my right at the very end of the table, and we'll go around the circle, and then we will introduce anyone who is online. So with that, thank you. If I could just interrupt briefly, try to turn on your microphone and push the button so that the red light comes on so it gets picked up by CTN. Thank you very much.
Good afternoon, William Anselmo. I'm co-director of domestic violence programs for Community Resources for Justice and Family Reentry. We provide psychoeducational classes to men that have been convicted or charged with domestic violence, intimate partner violence.
Attorney Nancy Tyler, former board member of Connecticut Coalition Against Domestic Violence.
Good afternoon, all. Alaric Fox. It's my great pleasure to serve as the Enfield Chief of Police.
Lieutenant Ryan Maynard, Commanding Officer of the State Police Training Academy.
TFC Richmond, I teach domestic violence to the Connecticut State Police Training Academy.
Kevin Doyle, Superior Court Judge in Part A in Hartford.
State Senator John Kissel, serving 8 communities in North Central Connecticut. I also serve as the ranking senator on the Judiciary Committee and work on DV matters with Senator Flexer for years and years. Thank you.
Good afternoon, Gail Hardy, Executive Assistant State's Attorney and designee for the Chief State's Attorney.
Thank you. My name is May Flexer. I am a co-chair of this council, and I am a state senator from the 29th district, which includes the towns of Mansfield, Wyndham, Scotland, Canterbury, Brooklyn, Killingly, Putnam, Thompson, and Pomfret. And as Senator Kissel said, I get to work with him closely in the Judiciary Committee, where I serve as the vice chair.
Thank you. Mark Pelka, Criminal Justice Policy and Planning Undersecretary at the Office of Policy Management. I direct a division that administers a variety of federal grants, produces data analysis and research reports, convenes stakeholders across the criminal justice system, and works on policy development and implementation. And I'm excited to be participating in our second meeting and look forward to the work that lies ahead. Thank you.
Good afternoon. I'm Joe DeTuno. I'm a director with the Connecticut Judicial Branch. I oversee family services.
Afternoon, CJ Forcier, Regional Manager for Judicial Family Services.
Good afternoon, Mary Kazicki, Director of the Judicial Branch, Office of Victim Services.
Good afternoon, Merritt LaJoy. I'm the Complaint Officer for the Office of the Victim Advocate.
Karen O'Connor, Executive Director and CEO of the Network Against Domestic Abuse, serving North Central Connecticut, also a retired State Police Sergeant.
Good afternoon, Andrea O'Connor. I work for the Umbrella Center for Domestic Violence Services. I supervise the court-based victim advocates in Derby, Milford, and New Haven courts.
And I believe we have one member online.
Hi, I'm a member of Tammy Nuccio. I don't know if you're referring to me or not, but Tammy Nuccio, state representative of the 53rd district, which is Tolland, Wellington, and Vernon. And also, sorry for missing the first meeting. I had a issue that I had to attend to.
Thank you, Representative. Are there any other members?
Also, Attorney DeCara is present online. Remember, I'm an attorney in private practice dealing primarily with family law, past president and long-term board member of the Prudence Crandall Center.
Great, thank you. Thank you.
Good afternoon, Chairwoman. Also a member designee for Commissioner Guidos with the Connecticut Department of Correction, and my name is Eulalia Garcia.
And also, good afternoon, everyone. I'm a relatively newly appointed member after the first meeting, so I'm sorry for having missed it. My name is Heather LaRock, and I am the Support Services Captain with the Windsor Police Department.
Thank you. Thank you all very much. And glad to have such robust attendance today at this council meeting. And last month we talked about a variety of things, and that has informed the agenda for this afternoon. And I want to express gratitude before we move on to the next item on our agenda to our colleagues on this council from the judicial branch who've put in a lot of work to give us a presentation today on the existing GPS program and its expansion at CSSD. And I think I'll turn it over to Joe and his colleagues for that. So thank you very much.
Thank you, Senator. I'm going to try to get this up and running. Just bear with me. Good afternoon. I'm going to give a brief overview of the expansion of Alert Notification GPS and talk a little bit about the program. It's not going to be an in-depth discussion of the program, but just an overview. My hope is that this program will be part of a subcommittee where more detail can be given about it. But this is just a brief overview of our expansion and what we've been doing since the Senate Bill 5 and the Public Act 23-106.
Joe, if I could just ask one favor, can you make that a little bit bigger? There's a zoom function at the top of your screen.
Does that work?
A little bit. Yep. Then I think all the members here in person can read it hopefully from their seats. Thank you.
So this past legislative session, Senate Bill 5, an act strengthening the protections against and response to domestic violence, was a fairly robust bill that was mutually set by the legislature, enacted. It mandated the judicial branch to expand our alert notification GPS program, which is in Bridgeport, Hartford, and Danielson, statewide by October 1st, 2025. In preparation for that bill being passed, we met, the judicial branch court support services division met with our chief court administrator, a deputy chief court administrator, and our chief administrative judge of the criminal division to talk about how we were going to roll this program out and how we were going to expand it. And the decision was made to start with Derby, Milford, and New Haven courts as the initial sites we were going to expand to. The main reason, it was close to Bridgeport Court, which certainly has been running for about 13 years. And we thought that it would be good to start in those locations. What we tried to think about is really going to 2 smaller courts and 1 large court every time we expanded, and in a way that made some sense. And we'll talk about that rollout. But we started with those 3 courts. But to implement this program, there's many things and many steps that have to be completed with both internal criminal justice stakeholders and external partners before we can really start a program in earnest in any one of those courts. So in terms of expansion that we've completed so far, even before the legislative bill, when Enfield Court was put into GA 14 in Hartford, we had to expand to those cities and towns that were in Enfield. So we did that in January of 2023. And so far we've expanded to Milford Court on November 1st, 2023. Offenders have been put in that program in Milford. And on November 15th, the Derby Court went live and having offenders being put on the program. In terms of next courts, we did a lot of work in the New Haven Court. We did all our work. However, there was an HVAC problem in lockup, and we needed to push that start date past the holidays. So the proposed start date for New Haven is approximately January 24th, but depending on when that construction is going to be completed, it could be earlier than that date. After that, we're heading to Waterbury, Torrington, and Danbury. Tomorrow, we're starting in Waterbury with the administrative judge, and we're starting our meetings with the Waterbury Court. After we finish Waterbury, Torrington, and Danbury, the majority of the western part of the state will be complete. Stamford, for a lot of different reasons, is going to be pushed into the next series of rollouts. So for the most part, the western part of Connecticut is going to have that program. After we finish Danbury and Torrington, we're going to be going to the middle part of the central part of Connecticut to join Hartford, which has been live since 2010. But we're going to go to Middletown, Meriden, and New Britain next. And then we're going to finish off in the eastern part of the state, Manchester, Rockville, Norwich, New London, and then we're going to finish with Stamford. And that would be then the whole state would have alert notification GPS. Those are tentative timeframes as we move forward. Right now, we're probably ahead of schedule, and I think we'll continue to be ahead of schedule as we move this out. So from July 1st, I've been responsible for implementing alert notification GPS, and how we do that and how I decided to do that was to have many large system meetings and hopefully present this to as many stakeholders as I could. And I want to thank many of our partners around the table for allowing me to come into their supervisor meetings, and there's been great collaboration so far, for which I'm internally grateful for. To roll something like this out, it takes that type of collaboration. But first, we started with the judicial branch, and we met with the chief court administrator and the judicial branch leadership, really just in terms of how are we going to roll this out and what's really the best way to do that. Then we met with our court operations, that our leadership there, they oversee the clerks in the criminal court, and the marshals, which are a significant part of what we need to do to roll this out. So again, thanks to the court operations leadership, Ty Erickson, Krista Hess. And then obviously our CSSD leadership, Gary Roberge is my executive director. So family services, obviously that's the division I oversee. And then we have pretrial services, which many of you might know as bail. So we started with the judicial branch, and then the chief state's attorney. And I want to thank Gail Hardy for helping me get meetings together. And obviously the chief state's attorney, very receptive to me coming to a state's attorney supervisor meeting. I presented the program to them as a way to just begin the process. The chief public defender invited me to their supervisor meeting. So I did the supervisors of the public defenders. And then obviously CCADV, our partner in this work. I met with their leadership, but I was also able to present alert notification to a statewide meeting of the Family Violence Victim Advocates, and also a separate meeting for the Safe Connect 24/7 staff. In terms of law enforcement, obviously they're the biggest external partner I need to reach, and I'd like to thank Dan Cargill for all his support, helping me email all the chiefs, getting all that in line. The chief state's attorney allowed me some time at their legislative meeting for law enforcement. There was probably about 80 to 100 officers there, and I was able to present on alert notification GPS. Dan invited me to 3 LAP quarterly meetings, so I completed that work. And then post the officer training, I was able to do some classes there. So I taught a post class, a few of those, and they were well attended. Some were canceled, but for the most part, I think I did 3 of those post trainings. And I also did a presentation for new dispatchers. And I have a nice connection there. And when they have a statewide meeting of dispatchers, I'll be able to also present. So there's a lot of work in terms of getting the word out, having people understand the process, and really for me to give them as much information as I could, and have them have a name that they can reach out to if they have questions. So a lot of work during the summer and early fall to get this ball rolling. As we went to individual courts like Derby, Milford, and New Haven, one of the things that CJ and I did was have local individual meetings with all our partners. It's always good to have one-on-ones or smaller meetings with people on a local level. So those are the individuals that we talk to. Obviously, we always start with the judges, but the prosecutors, public defenders, clerks, marshals, family violence victims advocates. I mean, Andrea she's the Milford, Derby, New Haven person. She's been a great resource for us as we roll this out. And then obviously trying to meet with law enforcement. CJ and I met with some Derby officers. We went to the Derby PD, and I've had email and telephone conversations with a few individuals from the Milford PD. We're working with New Haven now to try to get some training there. I have a few contacts that I have, and I'm going to be setting those up. But really the idea is to talk about at a local level how implementation is going to impact those individuals resource wise. How are they going to implement this and help us roll this out? So again, for the first 3 locations, obviously we've had a lot of collaboration, a lot of cooperation. The most important meeting, and we've completed those for Derby, Milford, and New Haven, is the local implementation team meeting. It's a large conference. Everybody's in the room, and we really talk about the nuts and bolts of alert notification, from arraignment to installation to dealing with non-compliance. But we discuss the rollout, any issues that an individual court may have, and some decision making. What's the ideas that are going to be put forth? So if something does come up, how are we going to respond? So those local implementation team meetings, again, are very important. And again, I think for the most part, the information and the rollout has gone fairly smoothly. Any questions on the rollout so far before I give a brief kind of overview of alert notification?
Yes.
Just have one question. You mentioned that the way this rollout is working, that the western part of the state will be covered in a particular period of time. Is there a reason why the western part of the state was an easier place to do most of this, other than the existing program that's already?
I think it really was Bridgeport
the
being
Wyndham.
the hub. In Hartford already being doing the program. It just made sense. We have a contracted provider that has to go to all these courts and install people. So we had to be sensitive to that as well. But there really wasn't any real, it was really, we wanted to start somewhere near Bridgeport, Milford, Derby, and New Haven made sense. And then we're just kind of we're trudging along.
Okay, I would be remiss if I didn't push back that, Norwich is near Danielson, and Rockville is, anyway.
Yeah. You had to start somewhere.
I know,
I have
I'm
a
just
question
teasing. You had to
also.
start somewhere, but I have to be a little parochial.
I have a question also, if that's okay.
I'm sorry, I can't.
Yes, Representative, go right ahead.
I'm going to follow up on exactly what was just said there. Looking at your plan, I noticed Manchester Rockville is not on the list until sometime in 2025. And I'm wondering how much flexibility there is in this plan, because while it might make logical sense to look at alignment, doing just the western, then the central, then the east does not seem equitable to me. And since Danielson already has this program, I would really like to see it rolled out into the Rockville GA 19 sooner than sometime in 2025.
I mean, my hope is that we do this faster than that timeframe. Everything's still on the table. We're trying to figure this out as we go. We've just begun our kind of implementation. So it can change. I just think that, you know, given what we need to do in terms of training and we're trying to do things in an orderly way. I understand that, you know, some courts had to be last and some were first. Bridgeport, Hartford, and Danielson have been a pilot for years alone. So I understand the issue that you raise. It really does depend on how this rolls out in terms of how quickly we can get to the other courts.
Yeah, I understand someone has to be last kind of a thing, but I guess I'm pushing back on the all of Western, all of Central, then Eastern. I think, like, from the perspective of trying to meet the demands of domestic violence across the state of Connecticut, if we could find a way to get, you know, a few in Western, a few in Central, a few in the Eastern, I try to, rather than waiting till the very end for an entire corner of the state that tends to be left out of most conversations on a regular. So as a representative of that district, I'm asking that we review that and look for some sort of flexibility so we can roll this out to meet the demands of the domestic violence victims in the northeastern corner or the eastern side of the state also. So I'm just hoping that there's flexibility here to readjust and make sure we've got this program equitably across the state.
Thank you. In just terms of background, this pilot program came out of the 2010 Speaker of the House of Representatives Task Force on Domestic Violence. It really did establish for the first time in Connecticut GPS technology to really provide warning and notification to victims of domestic violence that an offender is within a predetermined area. And to reiterate, this really is warning and notification to victims that the offender is near that person. That is the whole goal of the program. That's what we try to make sure happens every time that occurs. And that's really how we're using our GPS technology. It really is for victim notification and to really alert them that a potentially dangerous situation is at hand. We started the pilot locations in October 1st of 2010. Danielson, Bridgeport, and Hartford were selected, and that was by the legislature. And we've been operating fully in all those locations since 2012. So based on the statutory criteria, this program targets high-risk domestic violence offenders who are charged with violating a restraining order or a protective order. And based on the risk assessments that the family relations counselors conduct every day in court, it's a comprehensive validated risk assessment. If they're high risk, then we're alerting the court that they've met the statutory criteria. The second prong, or the third prong, which I think is equally as important, is victims should be willing to participate in the program by receiving alerts. That's what the program is meant to do. And a victim should really want to receive those alerts as part of a day-to-day safety plan. The program does enhance victim safety by providing notification to them so that a predetermined safety plan can be put into action. And that's really where the family violence victim advocates really serve a tremendous action by helping victims come up with these safety plans so that if there is an alert, they know exactly what to do and what plan to put into effect. The program allows for mobile zones. If a victim chooses to carry a charged device, there's a mobile zone around that person 24 hours a day. And also stationary zones. And those zones are known addresses that the offender would know: work, home, school. Basically, the stationary zone is usually the home address of the victim, and that is a known address to the defendant because they're told not to go to that specific location. There's violation alerts that are sent to victims and law enforcement. Oh geez, I'm sorry. We have a 24-hour monitoring center that receives all these alerts, and then we'll let the victim and law enforcement know if there's non-compliance. So I want to talk briefly about the court process and the response to non-compliance. Every day there's arraignments for domestic violence offenders that occur in criminal court. Part of the role of a family relations counselor, the individuals under my direction, is to do pre-arraignment screenings of all domestic violence offenders. And one of the screening points is, do they meet the criteria for alert notification GPS? If they meet the statutory criteria, we're then notifying the court prior at the time of arraignment that the person has met the criteria for alert notification GPS. If the judge orders the program, it is made a condition of the person's bond and the protective order. There are individuals that get released from incarceration at the time of arraignment, and the person gets installed, but there's also individuals held on bond, and until they meet their bond, they have that condition of GPS on them. So when they do get released, they get the device put on them. We have a good relationship with our offender services, our contracted provider. They're called Sentinel Offender Services. They're the individuals that come to court and install the device on the defendant, and will provide the victim with the device if that person's fully participating. Typically, the victim gets their device in the community, and the offender is installed prior to leaving court. One of the reasons why this sometimes doesn't appear as such a rapid, just do the whole state all at once, is that Sentinel Offender Services has to make sure they have enough installers and we have enough court staff to do the program. And obviously one of the biggest challenges is educating law enforcement on what to do when there is an alert. Yes.
I just have two questions. If somebody bonds out from DOC, how does that work?
They're courtside bond only.
Oh, these are all court.
They have to come to court to bond out.
Good to know. Thanks. And do we have any stats on how many victims don't want to participate in alert in the 3 pilot programs?
You know, COVID, it just made everything kind of skewed. It's about 25%, 25 to 30%. But that is pre-COVID numbers. So we really are ramping up our stats and trying to figure out what that looks like as we expand to all these new courts. Now, with more victims wanting it, we've seen an increase. It's been about, what, 50%, 55% in the recent time. But if you're talking about, and during COVID and before, it was about 25 or 30. So we've seen an increase.
One other thing, Barrett, it's good to see you. I haven't seen you in a long time. How are you? Just to respond to that first question, all our judges are trained that when they administer a protective order with GPS monitoring, one of the things they'll say is, because they're setting bond and implementing the order at the arraignment, they will advise the defendant as just a second layer that if you were to post a bond outside of at a correctional facility and leave the facility without a GPS device, you'll be in violation of the court order, and that could lead to further sanction and charges. So there are many layers to this. Joe's done a great job, but I just wanted to chime in that, and again, the clerk's office is really good at documenting that and making sure that becomes part of the bond paperwork that gets to the Department of Correction. And I know we have a representative from the Department of Correction, they intake. So there's a lot of checks and balances that are put into place.
So any sort of zone violations or serious alerts are also sent to CSSD Family Services. So we have a monitoring center alerting the victim, sending law enforcement for serious violations. And at the same time, Family Services are getting emails about the non-compliance. Once we receive that email, we triage that email to make sure that, yes, that violation was something that is legitimate. And if that is, then we go to the court and we ask the judge and prosecutor to redocket the case. And that's typically what happens. If there is noncompliance identified by Family Services, they let the prosecutor and judge know. If the person has counsel, they're alerted, and then we'll bring that person to court to address the noncompliance. So in terms of alerts to the victim, how this works, if a victim carries a device or requests that alerts be sent to their cell phone, if there is noncompliance, they get an automated text to their cell phone. And that text tells them what type of alert it is, what type of non-compliance. Right after that, a live monitoring center person calls the victim on their cell phone. We also provide through the state of Connecticut cell phones to the defendant so that we can tell them, contact them, but also to the victim if they want a cell phone so that they have that telephone. The live monitoring center calls the victim, lets them know what the alert is, and will let them know where the defendant's last known location was. After that, if the alert clears, then the victim also receives a telephone notice that the alert has cleared. Yes.
I'm sorry, I really appreciate the presentations. It's excellent. I'm just wondering, like, in terms of inadvertent, let's say the victim lives near a highway and the defendant just has to use that highway going to and from work. So it's always going to be like bumping into that area. How do you handle that?
So, I mean, that's a issue. It's been an issue in Bridgeport and Hartford, and we've had a lot of experience. Typically the zones get moved away from the highways. So we're able to kind of move the zones, keeping the same 2,500 foot radius, but we try to move it away from the highway to mitigate that. But if it is a situation where the victim has a mobile device, the thing is the monitoring center is calling the victim and saying, you know, there's a mobile zone, usually a buffer zone, but there might be an exclusion zone. And then the monitoring center talks to the victim about how to get away from that situation. And the monitoring center is seeing the defendant moving and the victim moving. So they're giving victims live information about kind of what's happening. And then obviously they're sending local law enforcement. You're welcome. So in terms of 911, and, you know, obviously this is a resource issue for all law enforcement. And we're asking them when the monitoring center calls them on some very serious non-compliance to go to the victim. I think that's the big kind of thing in this program. It's not go to the offender, it's to go to the victim, secure that person's safety. So we're asking law enforcement to do that when there's a stationary exclusion zone, a mobile exclusion zone, any sort of device or strap tamper, and wherever the defendant becomes in a process called lost communication or no location. There's a lot of times where, especially if there's a defendant who works in a factory or some building that doesn't have windows, a lot of times, obviously, the device will go out of location, and the monitoring center calls the defendant to have them leave that building so they can get a point. But the most important thing here is the victim is always knowing what's going on, so that person can enact their safety. So that's a very, very brief overview. Obviously, I mean, I do more extensive presentations to law enforcement and to the court on the program. So that's just a quick overview. Any questions on that?
Joe, thank you for that. I just want to say that I've had some experience in my previous life with ones that weren't real. And I do have an advocate working in a court that does have the monitoring now, and there's great communication when there's an actual violation. It would be really wonderful if we could work something out statewide where, because I think a false alarm could be very traumatic for somebody. Sure. And we don't know about that. The family violence victims advocates don't know. We might pick up the phone and check in with that, even though it wasn't an actual violation, just to make sure that all those calls might have stirred something up. So that would be really something that on my wish list.
Exactly. And one of the enhancements with the expansion is Safe Connect. So the Safe Connect through CCADV are going to get the same email alerts so that after hours, or if a victim needs assistance, another layer of advocacy can be through that.
Thank you. That's great.
Joe, I have a quick question. A simple zone not simple zone violation, but a zone violation, does that constitute a criminal offense? Would that be a new criminal offense? Or does it have to be like a violation of protective order within a certain amount of feet of the person?
I mean, I think if the person violates that zone, on the protective order says that the person cannot go within 2,500 feet of the victim. So that would certainly be a violation.
So it could be an on-site arrest if the police show up.
It could be. I mean, the reality is that most of the time there are warrants if that happens. right? The person doesn't stay in the zone, but there's an investigation that happens. And then obviously the difference is that family relations counselors are getting the same alert violation of the stationary zone. They're going to the prosecutor and the judge saying, hey, we have non-compliance. And then the redocketing really is when the consequences happen for someone who does that, including a new arrest and maybe a new charge. Would that be accurate, Judge?
Yeah, and I think it's part of that team approach, but I know when I was sitting in Bridgeport, anytime that there was any concern, everybody that was on that docket would notify the judge and we would get those cases brought back. And to me, from my early experience, that was kind of the most telling, that they realize that they're being watched, that everyone's taking it serious. And I found that in the beginning led to less problems later for the most part.
And there's a time frame to have them redacted within.
It's usually within the day. You know, it could be the next day. It goes pretty quickly because everyone, and like we said, we would notify if they had a public defender, they'd be notified right away. It's going to be on the docket tomorrow. We expect them back and it would be dealt with. And I think that's a key part of dealing with it efficiently and quickly.
Thank you.
Thank you, Madam Chair. I really appreciate that presentation. Thank you for all your hard work in the branch to implement this and to lay out the timeline. I just had two questions. I think some who might be watching this might be wondering, why is a high-risk person charged with a family violence charge like in the community? And I was just trying to, could we characterize kind of what would lead to that person and not being in DOC pretrial, instead being out? Is it, you know, they made bond? Is it that the overall circumstances? They're just trying to.
Yeah, I think that they would have made bond. Yeah, I think that's the quickest answer. That would be the case. You know, all this happens at arraignment. So again, it could be the person was locked up and then the bond is made after that. For me, I think the most important thing is that the condition of any sort of movement in the community is going to be something to this level, in this level of kind of surveillance as we're watching that offender and making sure the victim is safe. The difference, I think, for us is that the victim is now central to the process, where the victim now gets all the notifications and they have choice relative to fully participate by carrying a device. But if they don't feel that that's the measure they're comfortable with, they can get just the alerts on their phone. They don't have to have mobile zones. So we want to make sure that the victim is a part of the decision making, and really that this is an enhancement to their safety. But it's not perfect, obviously. You know, it is certainly enhancement where, you know, obviously law enforcement is going to a victim if the offender goes near that individual. So I also like the collaboration with the victim's advocate, the safety planning. I think all this kind of raises it to a much different level. So if you're talking about a high risk offender, I think that the measure that we're trying to put forth is something that meets that level of risk.
It's really helpful and encouraging to hear early on the use of the actuarial risk assessment and also review of past and current behaviors to apply the most appropriate level of surveillance supervision for that individual. And Joe, you may not be the right person for me to ask this, so perhaps others may wish to weigh in. I was really encouraged by the role of the criminal justice system being activated, from police to the courts, law enforcement, including the courts and the law enforcement, including police and prosecutors, as well as the courts. I was also excited to hear about the engagement of the victim advocates and the safety planning, because that's kind of follows the victim. You have the response to the defendant offender, and then you have some activation of victim supports. And I was wondering if there's an example of types of safety planning and execution that occurs to support that victim if the GPS goes off, and what might be missing that could be explored for strengthening, because it'd be great to marry the technology-driven responses with an actual human there to serve.
I mean, Andrea, do you want to take that? I mean, I think the victim advocates do a lot of safety planning for us. You know, we want to hold offenders accountable. I mean, that's the other part of this, is that if somebody is on this program and is non-compliant, that there's an immediate consequence. Family services doesn't meter that discipline or that consequence. We just alert the judge and the prosecutor that, hey, there's a big problem here. So I think it's just a question of, again, ramping up the consequences for that, which would not happen. in a lot of situations. So that's a positive. The other questions I think are probably best for subcommittee. I think that there's a lot of things that I think when a full presentation happens and we talk about a lot of the more detail oriented things, I think that might be an opportunity for all of us to take a look at enhancements. For me, having this be in Bridgeport, Hartford, and Danielson since 2010, basically continuously, I think that we've learned a lot of lessons, which I think now we're actually using as we roll out to the other sites and the other courts, because we have that almost over a decade knowledge of kind of where, as Senator Kissel talked about the highway issue. When we did the pilot, it was, we didn't really know what we were doing, but now we learned that you can shift things. You can, change the shapes of the zones. You can shrink the zones. Obviously you shrink the zones, you're shrinking the safety, but that might be something that a victim would want to do so they don't get a lot of alerts that aren't really emergent. So there's a lot of things that we've learned that now we have the ability to teach our family relations counselors. And as we present to law enforcement, it's a whole different presentation. I did them back in 2010. I did that rollout. So, I mean, just the nuances that you're able to give the partners that we didn't have back in when this rolled out, because we just didn't know. So.
Great. Are there any other?
Andrew, did you want to?
Yeah.
That'd be great.
Sorry, no, I was just gonna kind of comment on the safety planning aspect. So we have started in Derby and Milford. We have I think a handful of offenders that are on it. And the key part about us being in court as a victim advocate is we have confidentiality with those clients, so we can talk to them kind of off the record without the court knowing, and kind of make those tailor safety plans for them specific to that person. And what may work for one person may not work for the other. So it's really kind of talking about them in their specific situation. And okay, if I get a call for a mobile zone violation or a stationary zone violation, what am I going to do in that moment? And kind of thinking of ahead of what that's going to be. Do I have a packed bag? Am I going to go to my mom's house or a friend's house, somewhere that maybe the offender does not know the location of? If they don't have that family support, is shelter something that they're interested in doing? We make sure that they have our phone number for during office hours. So if something happens, in that moment, they need to talk to someone, we're there. They also have the 24-hour Safe Connect hotline for after hours if they decide, shelter in that moment is something that they're looking for, or they just need to kind of talk through that advice of, do I want to go to my mom's? Do I want to confide in a friend? If they have kids in common, what are the kids going to play a role in that safety plan? Go into shelter with them or go to mom's house, whatever it may be. And then Safe Connect is also when there's violations after hours, they are going to be notifying the court advocates. So in the morning, we will have access to that information and be able to follow up with the victim the next morning as well. So they'll have someone in crisis in that moment, and then also someone to follow up with them later.
Thank you. Any other questions or comments? Yes, absolutely. Yeah.
Thank you, Madam Chair. That was incredibly helpful. Thank you. And it would be great, we're looking, I believe, at model plan for law enforcement later today. It'd be great to learn more in future meetings about, what works in victim safety planning, and how is it applied, and that might identify some of the gaps that could be filled, challenges encountered by the member centers and programs across the state. Are there any particular challenges or needs that tend to be encountered with carrying out a safety plan that member centers could benefit from?
Put me on the spot here, Mark.
Sorry, we can hold for subcommittee too as well. We would
Yeah, no, I mean, a big issue is, clients, shelter is not really what they want to do. It is there and it is a confidential location, but especially if someone has kids, it's not something that they want to bring their kids into, but at the same time, they may not have that family support. Someone to go to. So that's always kind of a big challenge. Finances is always an issue as well. Shelter is a temporary place for this person to go, but it's not somewhere that, is realistic to stay long term. So financial stability and housing are really two big things that clients need. And then while we're on the topic and you're asking, I'm going to give you all my dreams. Legal aid is a really huge thing when it comes to divorce, custody, and immigration is also a big thing as well.
Thank you, Madam Chair, and thank you for letting me put you on the spot. And I know we'll be delving into much deeper in subcommittees and other venues, but thank you for.
All right, seeing no other questions or comments, Joe, I just do want to ask you two questions briefly, and thank you for this presentation and all of your work on this over these many years. You talked about the phone number. Just a simple question. Is the phone number one that the victim will recognize? You know, this day and age, we get so many random phone numbers calling us. Do they know who it is?
So if they carry the state cell phone, that's probably the only, either that or family services are probably the only two entities that would be calling them. So they're not really getting any
other contact.
Right.
Yeah.
So that is one thing. If it's their own personal phone, I do believe that they get a prompt. I don't want to give too much out, but they do.
Great. And then can you just talk about how your risk assessment has changed over time? I know many of the parameters in terms of who qualifies for this is in statute, but how has your risk assessment tool changed over the time this has been in place? And are there statutory changes that might need to be made so that more people might qualify for this if you think that's important for victim safety?
We're really following the statute, but in terms of our risk assessment, they're grounded in validation. And I think that's one of the things that separates potentially judicial branch, court support services division. We have two validated risk assessments, one that predicts rearrest for domestic violence, and we have another that predicts lethality or dangerousness, level of danger for the victim. Back right before COVID, the principal researcher, Dr. Kirk Williams, has been working with Connecticut since forever. It feels like forever, but since 2000, we made some very major changes to our risk assessment, really to deal with the question of bias. Although our assessment tools have never borne out to be biased in any way, the literature in the field was very clear that some questions on risk assessments tend to lead to some bias. So we took all the questions that were iffy and we took those out of the risk assessments. We added technology like stalking by technology in our lethality assessment, and we combined the two risk assessment tools into one DVSIR squared. And we thought more about temporal things. So did it happen within the past 3 months or 6 months? And that didn't really necessarily happen in our other risk assessments. So we really updated our tools. And right now, as we speak, it's being validated. And that's a process, right? You have to take a number of cases that have gone through the criminal justice system. And then he looks at all those, and he then looks at the rearrest data. And we're fortunate at CSSD, we have some really talented people in our BI unit that know how to do all that. I'm an operations person. So, but Dr. Williams is validating that new DVSIR squared. And we should be able to then look at, once that happens, what's the risk scores that now after the validation, we're going to use. So it should always be a high risk, in my opinion, situation, because a violation of protective order, when you have that in statute, that always raises it to another level. But we also have the ability to look at other serious crimes. So although the statute says violation of protective order, restraining orders, our family relations counselor, if it's assault first, if it's strangulation, if it's something really serious, the prosecutor and the judge and family services and the victim advocate as well can say, this is a GPS case. So there's a lot of collaboration when the alert notification program goes into a court and they deal with other situations and other crimes, not just the violations. And then there's other GPS. So say hypothetically, the victim chooses not to participate. Probation and bail have a GPS program, same device, same zones, same everything. The difference in our program is that when there is an alert and the victim wants to be notified, law enforcement goes to protect that victim. In the GPS program for bail and probation, the probation officer is the one that goes after and makes sure the defendant is held accountable. So there's always going to be GPS for the people that don't end up on this program because they might not meet a high risk or they might not meet a violation. There's another GPS program, not as intense, not as much of an enhancement, but again, there's GPS, which I don't think really is known in the community. I think people just think if they don't get the alert notification, they're not available for anything else. There is a bail probation GPS that does really the same things other than law enforcement is sent in my program, and my family relations counselors who aren't triaging the alerts.
Thank you. I appreciate that. Senator Kissel.
Thank you, Chairman Flexer. I really enjoyed this presentation and the colloquy has caused me to have a question pop in my head. I agree with the good judge that immediate response really brings it home to the accused that this is all being taken very seriously. I actually think that can be extrapolated to pretty much our criminal justice system as a whole. But that being said, I'm wondering, as much as this system has proven over since 2010 now to be very effective in those 3 jurisdictions, for specific cases, and I'm interested maybe in the subcommittee level, if there's any anecdotal stories of it's like in a nick of time or something was, it's always hard to prove a negative, but you never know. Have we been able to see from the experience that we've had thus far, any patterns emerge? I'm just wondering, you said that there's this researcher that's been helping us out, and I'm just wondering like if there's any tells. In other words, do people violate things in the middle of the night? Is there something that in the assessment that sort of tells people this person's at a higher chance of doing harm? Because I'm just thinking with this wealth of knowledge, albeit in a small universe, maybe we've gotten some other information that we can use to better arm ourselves to try to make sure this doesn't happen in the first instance, or to heighten our alert or sensitivities for certain things that are coming down the road. I'm just wondering if you were able to get anything.
I'm not sure necessarily if there's a pattern like that has been identified. I think that for me anyway, the victim tells the story, right? I mean, that victim is going to let us know really if they're concerned about potential lethality or something bad happen. And I'm grateful for the family violence victim advocates. They'll alert us to some cases that on the surface might not feel like it rises to the level of high risk, but there's things that are happening that really make it high risk. And so I think that the benefit of this program is the collaboration that goes from the family violence victim advocate, our family services staff who do the domestic violence arraignments every day, prosecutors who really do a lot of DV work, and they're doing the arraignments, they're prosecuting those cases. And obviously the most important is the judges, right? So we're seeing those cases, and I think there's a sensitivity to it. Can we say, for instance, there's a typology that A, B, and C happen? I think the legislature was keen with, if you're violating a protective order, then you're really not only not listening to a judge who's ordering you to stay away from the victim, there's something happening where you aren't being able to control yourself to stay away from that victim. And that is a heightened response. Our risk assessment, I think, really does line out what are those lethal factors. So I think we're hitting it there. So I do think there are those things in play. I'm just not sure if a researcher, to speak, has looked at it from a Connecticut perspective. Our researcher does just the risk assessment. That's his, he's really good at that. But in terms of the program and researching the program, I think that might be a subcommittee issue to say, hey, is Connecticut using, the best GPS program that's out there? I'm going to say, yeah, most likely they are. I don't know of any others that do what we do. And if so, is there some research that tells us something different? Maybe it's not just a violation of a protective order. Maybe there's something else. But I'd love to have a researcher take a look at that as I review our program, if that's something that the legislature thinks is important.
I thank you very much. And again, it's very heartening because I do think that Connecticut leads the way in so many areas. And I just think that this is just really wonderful. And I agree with everyone that's spoken parochially that the faster this gets deployed, the better off our folks are going to be. Thank you.
So when Jerry, Dan, and Megan say it's a 15-minute presentation, I shouldn't believe that next time. Is that kind of how it goes?
All right, seeing no other questions or comments, thank you. Thank you very much for that presentation and all that work. And to pick up on your last comment, Joe, I will try to keep us on time today. I know we promised folks a 2:00 end time, so I'll move on in the agenda. Members of the council were given before today's meeting and at last month's meeting, we discussed the creation of subcommittees for us to break into smaller groups and really delve into some specific areas that are a part of the charge of this new council. And so in a moment, I am going to pass to my right and to my left sign up sheets for each of the 3 subcommittees that are outlined here in the agenda. I will go over them briefly. I would ask that members who are physically here in person, please sign up. We can pass them back and forth a couple of times so people who need to think about it can get a second chance to put their name down on the list. But I will go through the 3 of these subcommittees now, and I would ask that members who are physically present, please try to sign up for what they are interested in today. We want to get these subcommittees working as quickly as possible. So it's important that folks choose that membership today. And for our members who are participating online, you will be getting a similar way to sign up. A sheet will be emailed to you, and I will ask that you please sign up as quickly as possible. And if folks have questions about the charge beyond the descriptions that's outlined both in the sign up sheets and on our agenda, please feel free to reach out to us and we'll get you that clarity. But the first subcommittee is really charged with the work of what had previously been the Law Enforcement Model Policy Governing Council that was melded into this new council. Many of our members around the circle here today were previous members of that council, so it may be something that folks want to continue with. Dan Cargill was the co-chair along with myself of that Model Policy Council or Governing Council over the last several years. And its charge is to focus on the review of policies and procedures that law enforcement agencies use when responding to incidents of family violence, including updating the model policy that has been adopted by all law enforcement agencies across the state and that is established by state statute. Dan will be giving us an update on the model policy a little bit later in our agenda today, but that's the charge of that subcommittee. We also have the Offender Intervention Standards Subcommittee that will focus on reviewing and updating domestic violence offender program standards as established by statute, and reviewing the pretrial family violence education program and any eligibility for such program. And lastly, our third subcommittee is the subcommittee on arrest warrants, orders of protection, the compliance, enforcement, and outcomes of those warrants and those orders. They will focus on the arrest, prosecution, penalties, and monitoring for violations of family violence restraining orders or criminal protective orders, and the processing of arrest warrants and the execution of arrest warrants for incidents of family violence, and the monitoring of compliance, enforcement, and victim notification of firearm seizure and surrender in family violence cases. So all 3 of these subcommittees have a pretty broad charge. I'm hopeful each member of the council will sign up for at least one of these subcommittees. Are there any questions about the subcommittees or the creation of the membership? Okay, I think I must have talked for too long then, so that's great. All right, so again, if members of the council can please fill out those sign-up sheets, and the council members online will be getting something electronically. I would ask that you try to do that today if you have the time. So next, as I mentioned a moment ago, we will have an update on our statewide model policy for law enforcement response to family violence. Dan Cargill will join us here at the table to give that presentation on that work. And that is a document that will need to be updated by this group sooner rather than later. The previous governing council had updated that document on an annual basis. As I mentioned, Dan had served as the recent co-chair, and I served as the co-chair of that body for, I believe, 13 years. And I know many of you have been contributing to that document and have been implementing that document around our state for quite some time. So Dan, thank you for preparing this update today, and the floor is yours.
Thank you very much, Senator Flexer. It's been my great pleasure over the last 7 years to maintain the model policy for the council. It's the police response to crimes of family violence model policy, which is a statewide model policy. As Senator Fletcher just mentioned, there are a number of people that have been around since the very beginning in 2012 when the council was formed, and out of Public Act 12-114. You had a very difficult time trying to hold together a number of resources, a number of best practices, a number of legislative mandates into a cohesive document. And I think you've done an excellent job. And over the years, it's morphed, it's changed a little bit, it's been modified, best practices have been updated. And I think we have today a well-balanced model policy for law enforcement's response to family violence, both from a legislative mandate side of things and the best practices side of things. So the law is very specific regarding the response to family violence by law enforcement. This statewide model policy serves as a meaningful guide for law enforcement when responding to that family violence. So the purpose of this policy is to make sure that people understand in law enforcement and the other individuals that interact with that survivor, understand that domestic violence is a serious event. The policy promotes officer safety, serves as a minimum standard for law enforcement, ensures that arrest decisions are made in accordance with the traditional probable cause standards and state statutes, and it ensures that victims of family violence are referred appropriately to the correct resources, such as CTC, Safe Connect, and the Office of Victim Services, as well as when there are children in the home during the event, that they are given mental health resources for that child in that local area. The policy you have in front of you covers a number of chapters, the recommended response and procedures for dispatchers, law enforcement, and their supervisors, or responding police officers and the supervisor. It gives arrest guidelines for on-site arrests, jurisdictional issues, as well as prohibited considerations. It covers dual complaints, dominant aggressor, and self-defense claims. When officers are involved in domestic violence, it gives clear guidance on how responding officers need to handle those cases, whether it's a member from that department or from a different department. It covers in great detail order of protection and provides a really handy comparison of different orders at the very back of it. And also it deals with, covers weapons and the seizure of weapons and the appropriate handling of that. It also goes on to review the federal domestic violence laws as well. Historically, as Senator Flexer had mentioned, the model policy is updated in December after the governing council has reviewed and made recommendations for the changes. I made those changes and then would send them out to the Police Officer Standard and Training Council for distribution through their website. The Connecticut Police Chiefs Association is a great help in ensuring that the updated policy is received by all chiefs. Every year, there's another document just beyond the model policy. Every year, chiefs have to fill out a compliance form that says that they are complying with the model policy, and it covers the 3 different sections: demographics, statutory requirements, and best practices. So some departments that have other resources can also check off the boxes within those best practices as well. That form has to be sent to the Department of Emergency Services and Public Protection to the Crimes Analysis Unit for verification. In June of every year, I send out a nice reminder to chiefs to have that sent in to help them out. This year, at the direction of this council, the subcommittee will meet and make recommendations for updating the model policy. And I look forward to that. Just from looking at the policy now, I think there might be some minor updates. Seeing that Joe DeTuno's presentation to the GPS monitoring system, there might need to be a few updates to that, as well as potentially some additions to the risk protection order section on page 22. I look forward to the subcommittee and the council making the recommendations and updating the policy for the new year. Thank you.
Thank you. Any questions for Dan? Yes.
Thank you, Madam Chair. And Senator Kissel's questions earlier about patterns made me think about the lethality assessment. And I don't want to get a reputation of putting people on the spot with this, but I know I've heard from you many times, Dan, about lethality assessment program identifying factors that make a case high danger, strangulation, stalking. And I wondered if those, maybe you could just give a quick overview, highlight, big picture. I thought that might help inform our continued work around what are patterns and what have we learned make for high danger situations. Thank you, Madam Chair.
Thank you for the question. And yes, there are three main concerns or three continuing factors that present themselves when there is separation, a history of strangulation and stalking behaviors. Those are the most dangerous times for individuals that are experiencing intimate partner domestic violence. So that's what the data reflects. And it's held true in working with our advocates and directly with the survivors and asking them the questions in terms of what other things are going on within their life and the outcomes of that.
And those two questions are part of our lethality screen as part of our risk assessment. So Jackie Campbell, who's a national expert, helped Connecticut develop our lethality screen, and I believe she did as well with the LAP. So there's a lot of crossover in those two assessments.
At the arraignment stage 2, we ask a very similar set of questions to all of our clients as well. So we'll get the answers to stalking, strangulation, and separation, and they go to family relations, and it helps them to decide what the level of protective order. So if it's what looks like a relatively minor case, if there's yeses to those questions, it helps us get a higher protective order in those situations.
And I think that's the difference between Connecticut and a lot of other states. Our victim advocates are informing our risk assessment tools, as are we. We interview the defendants, they're interviewing the victims. So it's very much a robust assessment versus just talking to a defendant or just reading a police report. That really distinguishes Connecticut.
Thank you, Madam Chair.
Thank you. Senator Kissel.
Thank you. I just
Senator, hold on just 1 second. We have an additional follow-up. No. Did you have a question or did you have an additional comment?
It's less of a question, more of a clarification. So
Okay.
it may lead into what you want. It's just, I'm just on separation. I'm used to watching FBI, CSI, all those. And usually when there's children involved, like sometimes that ramps up a person's anger. And so I'm just wondering, what does separation actually mean between two parties, or when there's children involved? Who is actually being separated and how?
Yeah, so separation can occur in many forms. It can be just law enforcement showing up and now inserting themselves into or between the relationship between the abusive partner and that survivor, that victim that's experiencing that violence. So that could be part of the separation, or it could be a protective order, a restraining order, or it could be an arrest and put into an incarceration situation. So separation can mean a number of things, or if that survivor chooses to leave the relationship. So all of those things, and certainly the children being involved, certainly are factors such as finances and property, et cetera. Those are all factors. But the form of separation is varied depending upon the control that abusive person is inflicting.
Thank you.
Dan, the question is, and I appreciate you bringing up about, you're going to have to look at that after, the presentation of alert notification and GPS. But I do see in the special, in the document, you talk about probable cause. And I think some of the challenges that we have when we go out and have conversations with law enforcement is simply that they get a ping that somebody violated a zone. Again, they talk about probable cause and me not being in law enforcement. Again, that's one of the challenges. What would that look like? And what would that change be if you're saying you wanted to have further discussions and maybe modify this document to help law enforcement to say that in itself, is that probable cause that they need supportive evidence to apply for a warrant or actually make an arrest.
Yeah, so it's a great conversation for the subcommittee to have, and I hope a number of members would join into that subcommittee, just so we can actually have those conversations. But the basic line is, if it's probable cause that a violation has occurred within the standards of that statute, then an arrest should be made, or an arrest will be made if it's domestic violence, family violence.
Great, thanks, Dan.
Welcome.
Yes, Chief Eller.
Madam Chair, I'd simply use the opportunity to publicly acknowledge Dan for the help he's provided to the law enforcement world for a long time. I have the advantage of having some great local assistance as well, for which I'm very grateful. But this is a 30-page policy. It changes every year. The stakes are extraordinarily high. There's a lot of ancillary responsibilities that go with it. And my contemporaries and I are trying to push this out to anywhere from 5, 10, 20, in my case, almost 100 police officers to larger departments that have hundreds upon hundreds. And there's never been a time when I haven't been able to get Dan or Karen, for that matter, on the phone when there's been a pressing question that's needed an immediate answer. So I appreciate both of their assistance.
Thank you.
Thank you.
Any other questions or comments? Great. Thank you again, Dan. Thank you very much for the update. And I know lots of the members of the council are enthusiastically signing up for that subcommittee to continue this work. Next on our agenda, we will have an update on DV offender standards. And I believe, Joe, I'm going to turn it over to you one more time. Thank you for bringing so much information to this meeting today.
Well, everyone's very lucky today. My fellow co-chair, Jerry Wild, is here as well. I think for the DV standards, I think we really focused on two major areas. One is modification to the standards, which I think is very important, and also some quality assurance. In terms of modification to the standards, in the latter part of 2021, a staff person under me at CSSD, her name is Natasha Barrett, did some extensive research and literature review about the state standards across the country. She did a deep dive into every state. What are their standards? What does it look like? And really to determine if Connecticut continues to meet or exceed the national standards. And as Senator Kissel talks about a lot, is Connecticut is far above a lot of the other states in terms of domestic violence offender standards. But that doesn't mean there's not opportunities to improve. And she did a great job of looking at all those standards. She put together a PowerPoint in terms of what those areas are. And that was distributed to our membership. A subcommittee was formed, and in 2022, they agreed that those changes should be made to the standards. Natasha has been working on those changes. We've completed the document, and now we're just kind of waiting for this committee to kind of take shape. And we had it done a few months ago, but we waited. So there's a document that a subcommittee is going to be able to review in terms of those changes. That PowerPoint can be distributed to everybody, but I think we need some foundation. I think people need some foundation before they read that PowerPoint about what we're doing. And as compared to the standards we have in Connecticut, which Nancy Turner, who I think is a member of this body, she did in 2014 a great job of compiling all the state standards. Merritt was on our subcommittee, and Nancy Turner did a great job. And that was the document that lived for quite some time. But after 10 years, we want to make sure that we're still on the cutting edge, and it looks like we are. However, the areas that she identified were substantive, and I think it's going to be a better product as we move forward. In terms of quality assurance, we have a provider list, and she was able to contact all those agencies just to make sure they're still in operation. We found that one provider was no longer doing the interventions in the community, and they were taken off the list, and we added several more. We developed a survey for the agencies to respond to about any challenges they have, where they're getting their referrals, and other things about the operations of the program. And those results were shared with our council. And then we had a updated protocol regarding approval of new providers. It was developed and was put into practice. So those are really the two major areas. The modification to the standards was a huge lift. And I'm glad that we were able to complete that endeavor, and hopefully it's something that will resonate with all of you as you read it.
Thank you. Any questions or comments? Well, I would be remiss if I didn't thank Joe for that update and for his leadership and for Jerry Wild's leadership in this area and moving forward with this new council on these areas as well. So thank you both very much. Okay, with that, I don't believe there's any other business to come before us. And as we had discussed at the last meeting, we really want to give the next several weeks for the subcommittees to start to do their work and to meet frequently and be able to produce some real work product in the weeks to come. And so I think the best thing for us to do in terms of this full council is plan for our next meeting. Last meeting, we decided we would meet at this time at the last Wednesday of the month. That would put our next meeting on January 31st at 12:30. We had joked a little bit at the last meeting about meeting the week between the Christmas holiday and the New Year holiday. We're not going to do that because again, we would have a lot of family here enjoying our meeting with us. So we will meet as a full group between now on January 31st, but between now and then, we will get the subcommittees up and running. You will be hearing from folks about when those are scheduled for. And if anyone hasn't had a chance to sign up, I haven't gotten one of the sign-in sheets back. So if folks want to pass that committee sign-up sheet back to me, that would be helpful, unless someone is really struggling and they want to be on all three. So with that, I don't believe we have any other business before us. Again, the details for the subcommittee meetings will be coming to you quickly. I appreciate the members of the council signing up today. And Representative Nuccio, do you have a question?
I would just like to, I'm not there, so just wanted to sign up for the third subcommittee if possible, please.
Yep. Okay.
I'm very interested in the first also, but I just don't know the time commitment on two, so.
Okay, I appreciate that. Thank you. We will make note of that. And the other folks online, we will send you a similar sign-in sheet that you can fill in online. Thank you, Representative. Any other questions or comments?
Happy holidays.
Senator Kissel says happy holidays. Maybe he also wants to make a motion. Senator Kissel makes a motion to adjourn. Is there a second? Seconded by Karen O'Connor. Thank you all very much. We are adjourned.